Hello, everyone. Welcome to my channel. Welcome to my channel, Shirley's Channel Chatter, right here on YouTube. So, in my previous video, I talked about some, various law terms. So, I'm going to talk about a few more law terms today. And I talked about some philosophers too in my previous video. So, most of my videos here on YouTube will be geared to business, law, accounting, legal issues in the news, current events, current legal cases in the news. So I'll be having some videos on those topics. And like I said, I'll be talking about business, anything business related, marketing, advertising, promoting, running a business, starting a business, ideas on, purchasing inventory, office supplies, anything pertaining to business, because my channel is going to be educational, inspirational, and enlightening. No gossip, but I will have some, some cases, some, current event, I guess I would say current cases in the news. I want to see the updates on those cases, how things turned out in a particular case. I would like to make sure I present that on my channel. So let's get started. So I'm just going to start out with a few more law terms. In my previous video, I talked about, law terms like interrogatories. I talked about mens rea, actus rea, plain view doctrine, with the plain view doctrine and the plain field doctrine. I want to get a little bit more into those two terms today. So the first term I want to start with today will be, let's talk about the subpoena. So the subpoena is a command issued under a court's authority to a witness to appear and give testimony. So that's what they call a subpoena. But let me also further look SUBPOENA. So I also want to say thanks for joining me. Thanks for joining me today. Glad to see you. Glad you could be here. So hit that subscribe button if you want to. So hit the subscribe button. I'm trying to bring enlightening, educational, inspirational content to my YouTube channel. So I have about 4 channels here on YouTube. So I'm just concentrating on this one today. So this one is my Shirley's Channel Chatter. Then my other channel is Everything Shirley, and then I have Education Unlocked, and then I have another one, Shirley's Legal Reviews. So on that channel, I'll be reviewing a lot of current law cases in the news. It don't have to be, it could be, it's all going to be law related. So it's going to definitely be legal cases in the news, because I want to keep, up to date. I want to keep up to date. I want to keep I want to keep my subscribers, keep them current on the news, so they know what's going on with these various cases. We have the R. Kelly case that's in the news, and we have the Tyree Nichols case. Then we have, I think those are the only two. Tyree Nichols, and then I haven't reported on the Shanquella case, so I want to give an update on that. I want to find, do some research, get an update on that. So various cases that, legal cases in the news, I want to make sure I give an update on my channel. So I have videos on my channel that you can click on. You can click on certain videos and it will give you an update. But let's get started. So subpoena, I said, it's a command issued under court's authority. So in other words, it could be just a jury duty. You can be expected to serve on jury duty, and they'll send you I don't know if they call it a summons, but they send you the questionnaire, They send you that questionnaire, and then you have to fill it out, send it back. And it's almost like a subpoena that you have to appear to jury duty. But a subpoena, if you need, they feel that they want you as a witness to a crime, judge may issue you a subpoena, so you will have to appear in court. So a subpoena is a writ ordering a person to attend the court. So a writ comes from the judge. So it's a written, in other words, a written command, I would say. A written command from the judge. That's what they call a subpoena. Saying, commanding you. That's what it says. It says a command issued under court's authority to a witness, as I said, to a witness to appear and give testimony. So that is subpoena. So that is the subpoena. So in other words, in a subpoena, then you also have the summons. It says to summon someone with a subpoena. It says the queen is above the law and cannot be subpoenaed. Well, that's just a sentence that they have. And they have a subpoena may be issued to compel their attendance. So in other words, subpoenas come from the court, so they issue you a subpoena. You definitely have to appear. So let me see. It says, what is the purpose of a subpoena? So like I said, so you can give testimony. A command to a witness to appear. They had the subpoena. No, that's another term. The subpoena duces tecum. That's what it says. A subpoena duces tecum. That's a command to a witness to appear and produce documents. So that's another term. But the first term was subpoena. So a subpoena is a legal document that commands a person or entity to testify as a witness at a specified time and place in a deposition, trial, or other hearing, or to produce documents or other tangible objects in a legal proceeding. In other words, you can be a corporation, you can be a business, and if the court issues you a subpoena, then you have to, it's a legal command from the court, legal written command from the court, saying that you definitely have to testify as a witness at a specified time and place. So either you have to do a deposition, or it'll be at a trial, or it'll be or other hearing. So let's go on to, and matter of fact, since that's in there, let's look up deposition while we're right here. Since it says, in other words, you get a subpoena, you have to, either appear for a deposition, a trial, a witness, in a trial, or a hearing. You might be a witness at this hearing, or it could be just a hearing, some other kind of hearing. You might not be a witness, but it says deposition, trial, or hearing. So let's look at deposition. Deposition definition in law. Okay, deposition is an opportunity for parties in a civil lawsuit to obtain testimony from a witness under oath prior to trial. So in other words, you have the deposition. The deposition, they have to appear, under civil law guidelines. They will have to give their testimony under oath before the trial starts. So that is the deposition. Let me put that down. Deposition. So in other words, parties to the civil lawsuit, they have to give their testimony as a witness. In other words, they are a witness. They have to give their testimony under oath prior to trial. So I will put under oath testimony prior to trial. Okay, so let's look up the next word. Let's go with suppressed evidence. And then I have another term called fruit of the poisonous tree. So fruit of the poisonous tree is when evidence has been obtained illegally, and hopefully it can get suppressed illegally obtained evidence is fruit of the poisonous tree. That's what they call. It's like, I mean, I wouldn't call it it's almost like a slogan, but okay, let me go with let's do fruit of the poisonous tree first. There you go. Fruit of the poisonous tree doctrine. It says fruit of the poisonous tree is a doctrine that extends the exclusionary rule to make evidence inadmissible in court if it was derived from evidence that was illegally obtained. So in other words, law enforcement, they illegally obtain evidence from that person or that person from their home or where their car or wherever they received it, wherever they obtained it, and they did it illegally. So it was fruit of the poisonous tree. So fruit of the poisonous tree is a doctrine. It stands the exclusionary rule. And also, I think I did exclusionary rule. So while we are here, let me do exclusionary rule. So exclusionary rule. So they have both of them together, so I'm gonna click on both of them. Fruit of the poisonous tree, that's a doctrine. But it doesn't say, yeah, it do say, well, it's just the same sentence. Fruit of the poisonous tree, I just read this one. Fruit of the poisonous tree is a doctrine that extends the exclusionary rule to make evidence inadmissible. So in other words, the evidence is inadmissible in court if it was obtained illegally. So let's go now to exclusionary rule. Because I clicked on it because I thought they were going to give me a definition of both of them. So the exclusionary rule. So fruit of the poisonous tree, illegally obtained evidence, inadmissible in court. It can sometimes be suppressed by your lawyer. And they obtain that evidence illegally. Should be able to be suppressed. Exclusionary rule, a law that prohibits the use of illegally obtained evidence in a criminal trial. So it seems like they're similar. So in other words, there's evidence that can be excluded. That's right in the name, exclusionary rule. It says in the United States, the exclusionary rule is a legal rule based on constitutional law that prevents evidence collected or analyzed in violation of the defendant's constitutional rights from being used in a court of law. So in other words, they came and they obtained the evidence illegally, and according to the Constitution, according to the Constitution of the United States of America, according to constitutional law, and if it's obtained illegally and it violates the Constitution of the United States of America, if it's in violation of the Constitution and the defendant's rights, then it could, that's what they would call evidence that can be excluded, the exclusionary rule, evidence that can be suppressed, evidence that's based on the fruit of the poisonous tree. So let me see, let's look up trustee. So I like that word, fruit of the poisonous tree. That's real nice. So I looked up a term. I already knew about this term, the broken windows theory. So I learned about that at Australia University. So I think I did do that on my video. I think I talked about that on my video yesterday. So this word, let's see, Trustee, trustee. So it doesn't say in law, but it says, let me click up here. So trustee, an individual, person, or member of a board given control or powers of administration of property and trust with a legal obligation to administer it solely for the purposes specified. So in other words, somebody passed away, and then they have to they have somebody to manage their estate, somebody they put in charge. So it says, then they may have a trustee as well, an individual, person, or member of a board given control. So the person will be given control and power over the administration of somebody's property in trust with a legal obligation to administer it solely for the purposes specified. So you might have to administer somebody's assets as somebody's assets from their estate, and as specified, even if they have a will, it will be specified in the will, but if they don't. So I talked about that, I think, on one of my videos too. Testate with a will. So intestate, the person died without a will. So let's go to the next word. Let's undo hardship. I have undo hardship, due process, motion in the mind, and I have nolle contender and pleadings. So let me start with undue hardship. So this term I do remember in my business law book. Well, you do have a word too. Look, undue burden test. Let me do because I never seen this word before. But let me do that next. Let me do the undue hardship first. Undue hardship definition. What is considered an undue hardship for a reasonable person, I guess. Undue hardship is defined as an action requiring significant difficulty or expense when considered in light of a number of factors. So in other words, undue hardship, you probably, you lost your job, you don't have no income coming in, you just, you need to get your food, you need to pay your bills, your income is very limited, and you just don't have too much money to do nothing. So undue hardship, you're facing undue hardship. So it said, what is considered undue hardship? Let me click. Undue hardship is defined as an action requiring significant difficulty or expense. So in other words, you have a significant difficulty, you have plenty of expenses that you can't handle because you have more expenses than you have revenue coming in. So I know I talked about in my accounting course down Strand University, we talked about the income statement, the balance sheet, statement of owner's equity, statement of cash flows. So the income statement, revenues minus expenses, will give you your net income. So if you have your revenues minus your expenses, and you don't have enough revenue coming in, yet your expenses are more than your revenue. Your revenues are less than your expenses. So but you never know in life. It happens that way sometimes. We have more expenses than we have finances, money coming in, revenue. Undue hardship is defined as an action requiring significant difficulty or expense when considered in light of a number of factors. These factors include the nature and cost of the accommodation in relation to the size, resources. I'm saying, your resources are limited. Resources, nature, and structure of the employer's operation. So employer's operation, an employer, in other words, that's his business. Employer, he may be running a business, and he may be facing, personally, we could be, as individuals, we can face undue hardship as well, but businesses they face undue hardship as well. Like I said, that these factors include the nature and cost of the accommodation in relation to the size, resources, nature, and structure of the employer's operation. So if everything, you're running a business and it's not structured right, everything is all out of order, no organization, and resources are limited, and you're just facing undue hardship in all kind of ways. Can't pay your employees, you can't pay your business bills, you can't do nothing when you're facing undue hardship. So let's look at, let me see. Let me look at, I got undue hardship, jury duty, it's a lot of undue hardships, but I'm not going to go over all of them. Let me go to due process. So due process, that's, we all are entitled to a fair trial. Due process. What is due process in simple terms? At a minimum, due process means that a citizen who will be affected by a government decision must be given advance notice of what the government plans to do and how the government's action may deprive them of life, liberty, or property. So in other words, you're facing a trial, and it could be you're facing a trial, and say for instance a criminal, it would be beyond a reasonable doubt. Civil, it would be the preponderance of the evidence lies within the plaintiff. That's in the civil law. But in other words, the government, and when it comes to criminal law, they are saying that the government has to let you know, in other words, due process, we all are entitled to a fair trial. According to the Constitution of the United States of America, we have our rights. We have our rights. So now let's look at also, since I'm on the due process, let's look at the Fifth Amendment. Fifth Amendment is due process. That's why I picked that one. The Fifth Amendment, so let's look at the Fourth Amendment and the Fifth Amendment. So let me see, I can read this, I guess. Has your property been damaged or destroyed by law enforcement officers through no fault of your own? Has the government refused to compensate you for the damage? We're the Institute for Justice, and we may be able to help. Oh, this is a company right here. The Fifth Amendment to the United States Constitution. I really didn't want to get into the fifth. I wanted to do the, that's why I wanted to do the fifth one first, then do the fourth. The Fifth Amendment to the United States Constitution requires the government to compensate property owners whenever it intentionally takes or destroys your property, but governments nationwide have been ignoring your rights. So in other words, government destroys your property, law enforcement comes in your house or your apartment, and they can come in there and have the wrong house, have the wrong apartment, they come in and destroy your belongings, then the government is supposed to compensate you. It says, when an armed shoplifter fleeing the police broke into a Greenwood village, this is an example, Colorado home and refused to come out. Police laid siege to the home. During a 19-hour standoff, officers used explosives, high caliber ammunition, and a battering ram mounted on the tank-like vehicle called a Bearcat against the house. The fugitive was apprehended, but the home was totaled. The innocent homeowners were never compensated. So this is, yes, in other words, they come in there, they, in an ordinary course of business, law enforcement, they try to apprehend their suspect, and then they end up, they say they had a 19-hour standoff. They try to smoke the person out, I guess I would call it. So they use explosives, they use high caliber ammunition, and they use equipment, big old tanks and whatnot, and then rammed it up against the house. So the fugitive was apprehended, but the home was totaled. It's an innocent homeowner, and the innocent homeowners were never compensated. So let me move on down. Now let me get out of this one here. So that was part of the due process, the Fifth Amendment. So let me go back and the due process clause, Fifth Amendment. So a due process clause is found in both the Fifth and the 14th Amendment to the United States Constitution, which prohibits the deprivation of life, liberty, or property by the federal and state governments, respectively, without due process of law. The U.S. Supreme Court interprets these clauses broadly, concluding. So we're talking about the Fifth Amendment. So a due process clause is found in the Fifth and the 14th Amendment. See, so we have the first 10 amendments to the Constitution, the Bill of Rights. So a due process clause is found in the Fifth and the 14th Amendment. They said the U.S. Supreme Court interprets these clauses broadly, concluding that they provide three protections: procedural due process, in civil and criminal proceedings, substantive due process, a prohibition against vague laws, and as a vehicle for the incorporation of the Bill of Rights. A vehicle for the incorporation of the Bill of Rights. So a vehicle, in other words, they mean a way to carry those Bill of Rights out, the way to implement them. So a vehicle, not a car, but a vehicle to carry the rights out, Bill of Rights. So then we have the clause in the Fifth Amendment to the United States Constitution provides no person shall be deprived of life, liberty, or property without due process of law. The clause in Section 1 of the 14th Amendment to the United States Constitution provides, nor shall any state deprive any person of life, liberty, or property without due process of law. So we're talking about the 14th Amendment and the Fifth Amendment. Fifth and the 14th Amendment. So the Fifth and the 14th Amendment deal with the due process. According to the Constitution of the United States of America, that protects the rights of the people. So the rights of the people. So let's see what they have. No free man. So this is something that this is a main article, due process, clause 39 of the Magna Carta provided. No free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. The phrase due process of law first appeared in the statutory rendition of the Magna Carta in 1354 during the reign of Edward III of England. So when you go way back in time and you read and do your research, even when you talking about the founding fathers of the Constitution of the United States of America, Declaration of Independence, you find out that it brings back memories and kind of joy, I guess I would say joy your memory. Joy your memory, because you're like, wow, yeah, I remember that. We talked about that in, high school. We talked about that in college. So due process applies to United States territories. It says it applies to the U.S. territories, although they are not states. The due process clauses apply to both natural persons, including citizens and non-citizens, as well as to legal persons, that is, corporate personhood. The Fifth Amendment's due process clause was first applied to corporations in 1893 by the Supreme Court in Noble versus Union River Logging R Company. Noble was preceded by Santa Clara County versus Southern Pacific Railroad in 1886. The due process clauses apply to non-citizens within the United States, no matter whether their presence may be or is unlawful, involuntary, or transitory. Although the U.S. Supreme Court has recognized that non-citizens can be stopped, detained, and denied past immigration officials at points of entry without the protection of the Due Process Clause, because while technically on U.S. soil, they are not considered to have entered the United States. So, in other words, due process, it says state and person. So, due process, it covers the state and the person, a person, a human being. So, it says due process clauses apply to both natural persons, including citizens and non-citizens. So, I guess if they, immigrants come over and they are on United States soil, then they are also entitled to due process, a fair trial. Yes, because it says it includes citizens and non-citizens, as well as to legal persons. Legal persons like corporations, legal persons, that is corporate personhood. And then it said the Fifth Amendment Due Process Clause, it was first applied to corporations in 1893. Imagine that. Due process was first applied to corporations in 1893 by the Supreme Court. And this case was Noble v. Union River Lodging, our company. Okay, so let me go down. So I get caught up in just, it's just information. I just love information. Learning. I love it. Besides money, it ain't in my ear. Information, knowledge. Yes, so money is the first thing. First of all, you need your health. First of all, good health. Good health, then money, education. And then you got your family, your friends, so all that coupled together. But health, number one. So we all have to get up every morning and thank God for our health and our family's health. It's a procedural due process, requires government officials to follow fair procedures before depriving a person of life, liberty, or property. When the government seeks to deprive a person of one of those interests, procedural due process requires the government to afford the person a minimum notice, an opportunity to be heard, and a decision made by a neutral decision maker. Okay, so that was, let me go on to the next one. I don't want to spend too much time. You can always look up, look up these terms, if you want a little more information. Subpoena, I got subpoena, suppressed evidence. Then the other one was subpoena, deuces tecum. So that's a command to a witness to appear and produce documents. Then I had, you can always, do some more research on that term there too. And then we also had the fruit of the poisonous tree. And then the fruit of the poisonous tree, then we had the exclusionary rule. Then I have undue hardship, due process. And let's go with the next term, motion. Motion to suppress evidence. So a motion, it could be a motion for this. I just wanted to say that. But I just wanted to say that. But let's say motion. I just love law terms. I like to look up these terms. Let's see, motion. Let me go. Okay, motion. When they talk about Newton's law of motion, 3 basic laws of classical mechanics that describe the relationship between motion of an object and the forces acting. But I'm not looking for that motion. I'm looking for, I'm gonna put on here lawyers, request, motions. When lawyers request a motion, let me see. Okay, motions for summary judgment, for example, can usually be brought before, after, or during the actual presentation of the case, motions. Let me go down here and see. We have discovery. That would have been a term. I didn't even put that down, but discovery. Discovery. So we're collecting, the lawyers collect evidence to help support their client in this discovery phase. The trial, let's see, let me, okay, I already did, I looked up that. Some of these words, I don't want to use the same. Let me go back, it's not coming up. Okay, let me go to Google. Motion to suppress. Okay, let me see what they have for me. Motion to suppress. Okay, a motion to suppress is a request, as I said. So the motion, so in other words, a motion to do anything, the lawyer may request a motion to do this, a motion to suppress evidence, or a motion to postpone the trial, or whatever he need a motion for. A motion to suppress is a request made by a criminal defendant in advance of a criminal trial, asking the court to exclude certain evidence from the trial. So that can be under the exclusionary rule, maybe. Yep. Well, it says the proposed basis for the exclusion must be in the United States Constitution. Let me click on this right here. Motion to suppress evidence. A motion to suppress is a motion that revolves around the exclusion of evidence from trial. So in other words, I just talked about fruit of the poisonous tree, evidence that had been obtained illegally. Then that's, fruit of the poisonous tree, evidence that your lawyer will definitely put a motion in to suppress that type of evidence. Because that is not giving you that's not giving you a fair trial. I don't know why I was about to say free, but fair. That is not giving you a fair trial if evidence had been obtained illegally. That's not a fair trial right there. So it says a motion to suppress is a motion that revolves around the exclusion of evidence from trial. In the United States, a motion to suppress is a request made by a criminal defendant. And I guess the criminal defendant has to, I guess that has to come from his lawyer. But it's right, but in other words, it's on that side. It's the defendant, and it's not the prosecution, but it's on the defendant's side. So the defendant definitely has to go through his lawyer to request that, so the lawyer can put it in. Lawyer put the motion in through the judge. It says a motion to suppress is a request made by a criminal defendant in advance of a criminal trial, asking the court to exclude certain evidence from the trial. The proposed basis for the exclusion must be in the United States Constitution, a state constitution, or some specific statute that permits such evidence to be excluded. A motion to exclude evidence that is based on rules of evidence in advance of the trial is more commonly called a motion in limine. I have that next on the list too. That is next on my list. Motion in limine, L-I-M-I-N-E. It's more commonly called a motion in limine. A federal courts rule 41. In federal courts, Rule 41 of the Federal Rules of Criminal Procedure governs motions to suppress. So in federal courts, Rule 41 of the Federal Rules of Criminal Procedure. The Federal Rule of Criminal Procedure. I like to get my hands on something like that. in federal courts. It's rule number 41 of the Federal Rules of Criminal Procedure. So the rules of criminal procedures, that would be something good to read. I mean, I would love to read something like that. The Federal Rules of Criminal Procedure, the concept of a motion to suppress is based on the exclusionary rule. The exclusionary rule, grounded in the Fourth Amendment, excludes from trial evidence obtained in violation of a defendant's constitutional rights and protects citizens from unlawful searches and seizures. Unlawful searches and seizures, I believe that comes under the Fourth Amendment. Illegal searches and seizures. In Simmons versus United States, the Supreme Court explained, in order to effectuate the Fourth Amendment's guarantee of freedom from unreasonable searches and seizures, this court long ago conferred upon defendants in federal prosecutions the right upon motion and proof to have excluded from trial evidence which had been secured by means of an unlawful search and seizure. So they came in your house, your car, your house, or on your property, implemented an unlawful search and seizure. So they searched it, they seized some documents, or they seized some, whatever they seized, and it was unlawful. It was an unlawful search and seizure. So it says, and then it says, an example of a motion to suppress is where the defendant requests the court to suppress a confession by the defendant to the police that was obtained as a result of a Miranda violation. So in other words, a Miranda violation, they probably were not read their rights, their Miranda rights. So I know we talked about a case in our law book, my business law book, Ernesto Miranda. So when he was arrested, he was not read his rights. According to the Constitution of the United States of America, you have to be read your rights, because they're violating your rights if they don't read you your rights, because those are your constitutional rights, so you can plead the fifth, remain silent, say, I plead the fifth for fear of self-incrimination. I don't care to say anything. Let me obtain my pro bono lawyer, or I have a lawyer, or I have a paid lawyer, whichever the case may be. Sometimes we don't all have to be lawyers. But I think we all should learn a whole lot about the law. You can order law books. I have law books. I have a whole set of law books, and that me and my husband purchased. And also I have some single law books that I purchased when I was down in Straight University. But we all need to learn the basics when it comes to the law. So just because we don't want to go to law school, or some of us may want to go, but depending on our finances. But put that to the side. But even though you might want to go, you might not want to go, but I think we all still should do a little reading, learn at least the basics, learn how the court systems are structured. You have the trial courts, you have the lower courts, you have the appellate courts, then you have your Supreme Court. I mean, I need to do a little more research and reading myself, but you might not want to be a lawyer, but still learn a little bit more about the law. Do your research, do some reading. You can purchase law books right online. That's what I plan to do. I want to purchase me a couple more updated law books, because I have a set of law books, but they are not updated, but they do have a lot of good information. The basics. So just order you a couple law books and continue to read and learn about the different terms. Like I learned, when I went straight to university, I learned some law terms. I took only, I think, I took one course, I took a lower course from Straya, and then and then I just kept my books. And every now and then I review. So, terms like fruit of the poisonous tree, and motion, mens rea, actus rea. Then a couple more terms I want to get into. Plain view doctrine, the plain field doctrine. So, in other words, plain view, the officer, or someone from law enforcement, they roll up on you and you're in your car, and they see something in plain view. You have a weapon on the seat. And you forgot it was there, but he rolled up on you so fast because he said you ran a stop sign, and he happened to see a weapon on your seat, your passenger side, your passenger side seat in your car, but it's you already knew that it wasn't registered, because in certain states you can't, or we don't have an open carry law like they do in Florida, and I think there's a few other states. I think California, I have to look that up, but I know Florida has the open carry law when you carry a weapon, but everything, it still has to be registered, and Florida and California, but we don't have that. We don't have that over here in the DMV. So, so let me finish reading. What was I was looking at, let me see. Okay, I was talking about the, I think that's it for this one. Okay, they still talk about the exclusionary rule. The exclusionary rule grounded in the Fourth Amendment. Because in the Fourth Amendment, there would be no illegal searches and seizures without probable cause. So that's another term too, probable cause, that I didn't even put down. So, young adults, older adults like myself, I always found an interest in the law, learning the law, learning the basics, at least. You want to learn the basics so you'll be on top of things when something go down, and not even that, you just want to have the knowledge. And it feels good to know certain terms when you never know when they're going to come in handy. You never know. So let me go to, I have no low contende. So that was let me go back to Google and let me touch base a little bit more on the Fourth Amendment and the Fifth Amendment. So let's do the Fourth Amendment, and then we'll go into the Fifth Amendment. Okay, so the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, as I just said. So in other words, probable cause that I guess I would say it could be a reasonable suspicion, or it's a reasonable suspicion. That was mentioned in the Terry stop too, I think because I did the Terry stop too in one of my videos. So in other words, the Terry stop was all they needed, a reasonable suspicion that, and then they can stop you. And then when it comes to the Terry stop, they don't have to do no full search. They don't have to do no full search. They, the reasonable suspicion to say that, them guys over there, and that lady over there looks kind of suspicious, They stop you and do a half, I guess I would call, not a full search. But it says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the personal things to be seized. In other words, they have a search warrant, right? It has to be, well, in other words, first the law enforcement, they will see if they won't see, but they will, talk to the judge and see and let them know and say, hey, this is going down, blah, blah, I have a reason to believe that blah, blah, blah is going down, or evidence, I want, can I get the search warrant? However they do it, whatever they say, but, they go to the judge, get their search warrant. So the search warrant has to specify area to be searched. They have to describe the place to be searched and the person or things to be seized. In other words, we need to search this part of the place, the backyard, and we're looking for this, and we have our gut feeling is that it's whatever we're looking for is there. So, they go to the judge, get their search warrant. So that's under the Fourth Amendment, but they can't do that without a reasonable suspicion, I guess. Probable cause. They need probable cause because the Fourth Amendment, there will be no unreasonable searches and seizures. So if there are any unreasonable searches and seizures, in other words, if they are coming in and obtaining evidence, illegally obtained evidence, that would be part of the fruit of the poisonous tree and the exclusionary rule. So in other words, then you can, you would deal with your lawyer, and your lawyer will, try his best to get that evidence suppressed. So, but, I do have a long way to go too. I know certain terms, but I stay with my law terms, and I've been on top of my law terms for a long time, ever since I graduated college. I always review, always study. I study my accounting, I study my business, I study my law terms, so, and let me see, what was the next word I said that I was going, discovery, okay, probable cause and discovery. Oh, okay, the Fifth Amendment too. Let me do the Fifth Amendment first. So wait a minute, I did the fourth. Okay, let me see, which one did I just do? The fourth, let me see, the fifth. Okay, I think I just did the fourth. Okay, right, the Fifth Amendment, right, Fifth Amendment. I wanted to do the fourth and the fifth. Yeah, the Fifth Amendment says the federal government, I think I did this one. The federal government says, the Fifth Amendment says the federal government that no one shall be deprived of life, liberty, or property without due process. Okay, I just did this one. Okay, what else is in the Fifth Amendment? I think it's double jeopardy. Double jeopardy laws are in the Fifth Amendment too. Let me go to double jeopardy. Let's do double jeopardy, because I'm quite sure that's in the Fifth Amendment as well, and due process. It's in the Fifth Amendment. Right, so the Fourth Amendment is no unreasonable searches and seizures without probable cause. That's the Fourth Amendment. I don't know what this is. Okay, yeah, there you go. Let's go to, okay, let me go back to the Fifth Amendment. Fifth Amendment simplified. So we're talking about double jeopardy. No person should be twice put in jeopardy of the same offense. Okay, in summary, the Fifth Amendment includes allowing people to be indicted by a grand jury before going to trial, protection against being made to answer more than once for the same crime, double jeopardy. So the Fifth Amendment, I can't say it. The Fifth Amendment protects us against not having to answer or having to answer. It protects us, basically. It protects us from not having to be prosecuted for the same crime. Double jeopardy. That's in the Fifth Amendment. So then it says allow people to keep from self-incrimination, fair treatment by the courts. So in other words, a fair trial. You can plead the Fifth for, you don't have to, for fear of self-incrimination. Same, if they're reading you, the law enforcement, you're in a situation where they have to read you your rights. And, you don't have to confess at that time or none of that. So they're reading you your rights, and you have the right to remain silent. You have a right to remain silent. Everything you say can and will be used against you in a court of law. So something like that. So it said Fifth Amendment simplified the Constitution of the United States. Okay, I had that one. Then let's look up. Let me see. No person shall be held to answer for a capital or otherwise infamous crime. So in other words, a capital, that means the double jeopardy. So in other words, a crime for two crimes, not two crimes, but the same crime. Can't be charged, for the same crime twice. So the double jeopardy. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentation of indictment of a grand jury in 7 cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense. That's what I wanted to say. Offense to be twice put in jeopardy of life or limb, or nor shall be compelled in any criminal case to be a witness against himself. Right, Fifth Amendment. You can invoke the Fifth Amendment. You don't have to testify against yourself for fear of self-incrimination, nor be deprived of life, liberty, or property without due process. So due process of law, that fair trial that we all are entitled to under the Constitution of the United States of America, nor shall private property be taken for public use without just compensation. In other words, what was the other term? Eminent domain. So eminent domain, so that's why that's in the Fifth Amendment too. Without the due process of law, nor shall private property be taken for public use without just compensation. So in other words, the government can't take your property without just compensation. That comes under eminent domain. So the eminent domain laws. Okay, let's look up, let's go to discovery. And let me see, Google. Let's go to discovery. So I should have typed in law. But let me see. What they have down here. Let me type in law. I gotta type in law. So just lawyers. So lawyers in the discovery phase of a trial. Lawyers in the discovery phase of a trial. Let me see. I don't see it yet. Let me see. It say basic understanding of the legal discovery process. Let me try that one. Excuse me. Excuse me. Okay, this is under the what is legal discovery? All paralegals, either prior to graduation or prior to seeking employment, should start to become familiar with the process of legal discovery. It's a fundamental paralegal skill, and although the process is covered much more in depth in the Blackstone Career Institute Civil Litigation Advanced Paralegal Program. So this is a school that has a program. In other words, you want to be a paralegal. So paralegal is being a paralegal is a good way to start, out in the legal field. So I do have my paralegal diploma. It says, so in other words, this school called the Blackstone Career Institute Civil Litigation Advanced Paralegal Program. So I was trying to see if they had, I wanted to talk about the discovery phase. She said a paralegal also must understand that the discovery process is critical to the outcome of a legal proceeding or trial. Right, so in the discovery phase, that's when they gather their evidence, or I guess on each side. But let me go over here. Let me type in, because I definitely want to. So, I'm going to type in the discovery phase of the trial. That's what I want to type in. What is the discovery phase? See, perhaps one of the most important phases of a trial is what's called the discovery phase, which occurs before a trial commences in a courtroom. The discovery phase essentially helps the two sides of a case set up their game plan for trial. So discovery, they set up their game plan, gathering the evidence, what to attack, when to defend, when to deflect, when to cast doubt. What is the discovery phase? Let me go here. So it says, what is the discovery phase of litigation? What are the rules? Okay, what is this? I want to talk about the. So in other words, they have a discovery phase in the civil. They have the discovery phase in the civil litigation as well as the criminal. See, what is the discovery phase in the criminal trial? So that's what I want to see. I just want to go through this real quick. The discovery phase is an important part of the criminal trial process. During this step, both the defendant and the attorney and the prosecutor must share information they have regarding the incident. Typically, this step takes place before the case begins. So in other words, you have the prosecution's attorney, and then you have the defendant, you have his attorney, then you have the judge. So in other words, they laying out their game plan, and I guess they have to let each lawyer have to let each other know evidence that they have. Where I have this, and they say the prosecution's attorney may say, hey, he may show the evidence that he has. They try to show each other. They have to share information. They have to share their evidence. So it said prosecutors must share information they have regarding the incident. So they all three of them must share their information regarding the incident. Typically, this step takes place before the case begins. How and when does discovery begin? Okay, so it says a court can enforce the provisions of the discovery law using various methods, which include but are not limited to requiring immediate disclosure, initiating contempt proceedings, preventing witness testimony, or presenting real evidence. What type of information is provided during discovery? During the discovery phase, both the prosecutor and defense must provide the other with the following information. As I said, names and addresses of people that they intend to have testify at the trial, statements of the defendants, evidence they intend to present at trial, written or recorded statements of witnesses, results of physical and or mental examinations, evidence favorable to the defendant. So don't come up with no strict stuff where you're trying to hold back evidence. so you can get a conviction on my client, evidence favorable to the defendant, make sure that's submitted, results of physical and or mental exams, written or recorded statements of witnesses, evidence they intend to present at trial, names and addresses of the people they intend to have testify at trial. So in the discovery phase, good cause means that releasing the information could put victims or witnesses in danger, result in evidence being lost or destroyed, harm other investigations carried out by law enforcement. So it says in the discovery phase, good cause means that releasing the information could. So right, they're releasing the information, but sometimes they have to still have, even when they're going to trial, when they are going to trial, sometimes they have to have protection because you have angry, some family members may be in the courtroom and somebody may be angry because this happened or that happened. I've seen it on TV, on YouTube, right here on YouTube, where they had several cases where family members, try to jump right on top of the defendant. Jump right on top of them because they feel like, right in the courtroom. So that happens. So protection still has to be in the courtroom just like on the street. How long does the discovery phase take? The amount of time it takes to complete the discovery process depends on the circumstances of the case. But it can be lengthy. To adequately prepare for a case, the prosecutor and defense must thoroughly review all the evidence and information the other side has. They got to thoroughly review all the evidence that each side has. So that's in the discovery phase of the trial. So this all takes place before the trial actually starts. They may also develop a question to ask witnesses and analyze the responses. So that's the discovery phase. So let's see what we have. Let's go with no-low contender. I think that would be, I think I only have a couple more. 1, 2, I just have a few more. Let's see, let me see. I'm going to skip down to negligence. And, okay, let me see. No-lay contender. Well, I already had that means no contest. So, I'm going to skip down to negligence after this one. Okay, a no-low contender, I spelled it wrong, is E-R-E. No-low contender. Plea has the same immediate effect as a plea of guilty. In other words, you're pleading guilty, but you have a different residual effect on consequences and future actions. What said no-low contender plea has the same immediate effect as a plea of guilty, but may have different residual effects on consequences and future actions. For instance, a conviction arising from a no-low contender plea is subject to any and all penalties, fines and forfeitures of a conviction from a guilty plea. See more. Let's see where it stops at. Yeah, in criminal trials in certain United States jurisdictions, it's a plea where the defendant neither admits nor disputes the charge. So, serving as an alternative to a pleading of guilty or not guilty. So, in other words, you're not pleading guilty or it says you're not pleading guilty or you're not pleading. Well, you're not pleading guilty, but you're not pleading not guilty. So you're not pleading guilty and you're not pleading, so really you're not pleading anything. That's what it sounds like to me. You're not pleading guilty, you're not not pleading guilty, it says to a pleading of guilty or not guilty. So the defendant is not admitting admitting to or disputes a charge. So he's not admitting to the charge and he's not disputing the charge. So in other words, I ain't gonna tell you that I did it, and I ain't gonna tell you that I didn't do it. So ain't no contest plea, while not technically a guilty plea, typically has the same immediate effect as a guilty plea and is often offered as a part of a plea bargain. In many jurisdictions, a plea of nolo contender is not a typical right and carries various restrictions on its use. In the United States, state law determines whether and under what circumstances a defendant may plead no contest in state criminal cases. So it says in federal court, the federal rules of criminal procedure only allow a nolo contender plea to be entered with the court's consent. So in other words, the court has to consent. In other words, you're not pleading guilty or innocent. And so it's up to the court whether or not they let you plead the nolo, I guess I'm saying it right, nolo contender. It says in federal court, the federal rules of criminal procedure only allow a nolo contender plea to be entered with the court's consent. Before accepting the plea, the court is required to consider the parties' views and the public interest in the effective administration of justice. A nolo contender plea has the same immediate effect as a plea of guilty, but may have different residual effects or consequences in future actions. So in other words, it's almost like you still pleading guilty. Nolo contender, it has the same immediate effects of a guilty plea. It has the same immediate effect of a plea of guilty, but it may have different residual effects or consequences in future actions. So that is the nolo contender. So let's go look up. So we have another term called pleadings. It's a written statement filed with the court to describe a party's legal assertions about the case. So it's a written statement filed with the court to describe the party's legal assertions about the case. So I want to look up a couple more terms. So the pleading in law is practical in countries that follow the English model. A pleading is a formal written statement of a party's claims or defenses to another party's claims in a civil action. So it's a formal written statement of a party's claims or defenses to another party's claims in a civil action. So if somebody have a civil lawsuit against you, then they will have a formal written statement claiming what they are suing you for. So that would be their pleading. So it would be formally written down. So it says a formal written statement of a party's claims, their claims or their defenses. In other words, they have a defense or they have a claim that this person did this or that to them. So that would be their pleading. It says pleading in early American law was done through common law writs. Under the federal rules of civil procedure, complaint is the first pleading in American law filed by a plaintiff, which initiates a lawsuit. So the pleading initiates the lawsuit. A complaint sets forth the relevant allegations of fact that give rise to one or more legal causes of action, along with a prayer for relief and sometimes a statement of damages claimed. Okay, let me go on. I'm going to go on to the next term. That's a word I haven't heard before. It's called an Alford plea. Then I'm going to go to the negligence after this. Let me see how much time I have. Okay, I'm over about 1:14. 1 minute. What? Not 1 minute. 1 hour. I'm over an hour 14 minutes, so I'm good time. So let's go for an Alford plea. So it says pleading. This is pleadings right here, but I don't know if that's going to be down here. But let me. So in other words, pleading, then they have to send out. Then it says that it has to be an answer. An answer is a pleading filed by defendant which admits or denies a specific allegation set forth in a complaint and constitutes a general appearance by a defendant. So that is the answer. You have pleading, then you have the answer. In other words, somebody send you the pleading, you get the pleading, and then you have to definitely answer. So let's go with Alford, the Alford plea. There you go, right there. Alford plea. I've never heard of this term right here, but that's what I'm saying. You learn something new. Or they say that is the defendant's plea. It says the Alford plea. It says in the United States, an Alford plea, also called a Kennedy plea in West Virginia, an Alford guilty plea, and the Alford doctrine is a guilty plea in criminal court, whereby a defendant in a criminal case does not admit to the criminal act and asserts innocence. So in other words, Alford plea, the defendant is not saying that he's guilty, he's asserting his innocence, but admits that the evidence presented by the prosecution would be likely to persuade a judge or jury to find the defendant guilty beyond a reasonable doubt. So that's criminal, guilty beyond a reasonable doubt. This can be caused by circumstantial evidence. That's a good term too. So that, circumstantial evidence, that's not direct evidence. Testimony favoring the prosecution and difficulty finding evidence and witnesses that would aid the defense. The Alford pleas are legally permissible in nearly all U.S. federal and state courts, except in the state courts of Indiana, Michigan, and New Jersey, or in the courts of the United States Armed Forces. So in other words, if you're in Indiana, Michigan, New Jersey, or the United States Armed Forces, they do not recognize the Alford plea. Because say Alford pleas are legally permissible in nearly all U.S. federal and state courts except Indiana, Michigan, New Jersey, and the United States Armed Forces. It says the Alford guilty plea is named after the United States Supreme Court case of North Carolina versus Alford. Let me read his case. Henry Alford had been indicted on the charge of first degree in 1963. Evidence in the case included testimony from witnesses that Alford had said after the victims that he had the individual. Court testimony showed that Alford and the victim had argued at the victim's house. Alford left the house, and afterwards the victim received and the victim was taken away. When he opened the door, responding to a knock, Alford was faced with the possibility of capital punishment and convicted by a jury trial. Okay, it says it was the default sentence by North Carolina law at the time. If two requisites in the case were satisfied, the defendant had to have pleaded not guilty, and the jury did not instead recommend a life sentence. Had he pleaded guilty to first degree, Alford would have had the possibility of a life sentence and would have avoided but he did not want to admit guilt. Nonetheless, Alford pleaded guilty and said he was doing so to avoid a D sentence where he to be convicted after attempting to contest that charge. So that's the Alford plea. And it's a whole lot right here. It's a whole lot to read. Alford appealed and requested a new trial. And he was forced into a guilty plea because he was afraid of receiving a certain sentence Supreme Court of North Carolina ruled that the defendant had voluntarily entered the guilty plea with knowledge of what that meant. So you definitely want to understand what you are pleading before you plead. So I'm not going to read all of that. So you can read more up on the Alford, the Plea, ALFORD. I'll put that in the description after the video. So let's go. We have allegations, we have arraignment, and we have arrest warrant, and I think those are the last three. So let me go to allegations. Let me see. Let me go real quick. Allegation. ALLE. Allegation. So in other words, allegations, we have, that's going into something else. Okay, in law, an allegation is a claim of an unproven fact by a party in a pleading, charge, or defense. Until they can be proved, allegations remain merely assertions. So allegation, it can be, allegation can still land you in court. You still can land in court over an allegation. In other words, they say, that gentleman, he robbed the store. That's an allegation, but they said it was him, but nobody saw him. Nobody saw him do it, but they said, allegedly he robbed the store. Allegedly he robbed the store, but they didn't have no direct evidence against him. All the evidence they had was circumstantial evidence. They didn't have the direct evidence. Nobody saw him. So they had, somebody dropped the watch at the scene. Somebody, footprints were in the sand, leading up to the store. Something, circumstantial evidence. So let's look up that word next, to matter of fact. So we have, then they have the disjunctive allegations. They are allegations in the pleading joined by and or in a complaint. Disjunctive allegations are usually per se defective because such a pleading does not put the party on notice of which allegations they must defend. So I know I had that word on here too. I think I had that on here. Per se. I think I had, I don't think I put that on. I thought I had that on here. Yeah, I do have it on here. No, I don't have per se. It's per se, but I have pro se. Pro se representing oneself, okay? No, I don't have that. I thought I had that on here. On here it say per se. So let's go with, okay, we did allegation. Let's go with the arraignment. Let's go with the arraignment. ARRAIGN. Oh, I spelled it wrong. GN. Yeah. Okay, arraignment is a formal reading. Arraignment is a formal reading of a criminal charging document in the presence of the defendant to inform them of the charges against them. In response to arraignment, in some jurisdictions, the accused is expected to enter a plea. In other jurisdictions, no plea is required. So in other words, the arraignment is a formal reading of a criminal charging document in the presence of the defendant. In other words, I guess that's the first appearance. So that's the first appearance in court where you enter your plea. It says arraignment is a formal reading of the criminal charging document in the presence of the defendant to inform them of the charges against them. Right, so you're being arraigned We're going to let you know about the charges formally that's been presented against you. So that is the arraignment. In other jurisdictions, no plea is required. So in other words, they can plead innocent or guilty, not guilty or innocent. Acceptable pleas vary among jurisdictions, but they generally include guilty, not guilty, and the preemptory pleas or pleas in bar, setting out reasons why a trial cannot proceed, pleas of no contender, no contest, and the Alford plea are allowed in some circumstances. So see, just learned something new today. We have the in the arraignment, they might have a chance to exercise the peremptory plea, the no contender, or the Alford plea. So it is allowed in certain circumstances. So the Alford plea is only allowed in certain circumstances. So you can look up more on the peremptory plea, no contender, and the Alford plea. Alford plea, ALFORD plea, and then the arraignment. So let's look at this last one on this page anyway. So we have we talked about the arrest warrant, we talked about the Miranda warning that she has to be read during Miranda rights, but there are certain circumstances where law enforcement might not read you your rights. So it's a lot to go into, because when you talk about warrants, then you go into, you're going into, different, types of warrants. Because they do have the, no-knock warrant, and then they have, in other words, if law enforcement feel that their life is in danger, they're not going to try to waste time to, ask the judge for a search warrant, or if they are in a pursuit of, and a defendant, he fled the scene of a crime, and law enforcement, and they are in hot pursuit, they're not going to stop and call or try to get a search warrant from the judge. So let's go into the arrest warrant. It's a warrant issued by a judge or magistrate on behalf of the state, which authorizes the arrest and detention of an individual or the search and seizure of an individual's property. So we talked about that previously too, and there would be no illegal searches and seizures come from the Fourth Amendment. So in other words, the arrest warrant. So you can read more on this, the arrest warrants, read more on Ernesto Miranda. So that's how the Miranda rights came about. When he was arrested, I think what is it, 1960, I think they said 1960, I don't know if it was 63 or 66, one of them. But he was arrested and he wasn't read his rights at that time, so that's when they came. That's when they introduced the Miranda rights. So now they put a lot of names, and even when judges went down into town and when they first dealt with common law, they went down into towns as they solved those cases. They became precedent cases. They became important model cases that they used to solve other cases, current cases. So let me see. I was looking for, okay, I don't think they had too much, okay, it says for the police to make a lawful arrest, the arresting officer must have either probable cause to arrest, and it also must have a valid arrest warrant. A valid arrest warrant must be issued by a neutral judge or magistrate who has determined there is probable cause. So like I said, that reasonable suspicion or that little bit of evidence that let them say that, or it might be more where that came from. determined there is probable cause for an arrest based upon sworn testimony or an affidavit in support of the petition for a warrant. The arrest warrant must specifically identify the person to be arrested, the person to be arrested, the area to be searched, and what are they looking for to be, what are they going to expect to seize. If law enforcement or fine provides false information or shows reckless disregard for the truth when providing an affidavit or testimony in support of an arrest warrant, they may constitute grounds to invalidate the warrant. Those minimum requirements stem from the language contained in the Fourth Amendment. As I said, there'll be no illegal searches and seizures in the Fourth Amendment. Federal statute and most, so we did not need to read more on the rest of the amendments too. Second Amendment, the right to bear arms. I need to read more on my amendments as well as 27 amendments. Freedom of speech and religion, freedom of the press is amendment number 1. Number 2 is right to bear arms. And we have the 4th and the 5th. So as okay, I think that's the last. There's some other words in here too. It's another term. Look, I never saw this term before too. It's called mittimus, M-I-T-T-I-M-U-S. Let me write that down. M-I-T-T-I. Mittimus. That's a writ issued by a court or magistrate directing the sheriff or other executive officers to convey the person named in the writ to a